Good afternoon, everyone, and welcome back to Stewarts Soundbites. We are on episode 14, and I'm not really sure how we got here, but we've made it. And today we've got it's a bit different today, and it's rather exciting. So we've got an international injury takeover. So you'll be very happy to know that you don't have to look at me and listen to me during this. We've got a partner at Stewarts, Chris Deacon, a partner in our international injury team, here with Solenn le Tutour and Ana Romero. And we're talking today a bit about accommodation claims and how they're calculated. Obviously, this is a hot topic in the UK at the moment following the recent judgment in Swift and Carpenter, which Chris is going to start with. And then we're going to have a look at what the position is in France and in Spain. So it'll be a really interesting session as normal, because we're only limited to 15 minutes. We don't have time for questions during the session, but if you do have any questions afterwards, please feel free to get in touch. You can type them into the Q&A box, or you can email me or Chris after the session, and we'll come back to you as soon as we can. All right, so I'll hand over to you, Chris.
Well, thanks very much, Emma, and it's a pleasure to be here today, and congratulations on the success of the Stewarts Soundbite series so far.
Thank you.
As you say, claims for accommodation following serious injury, they've barely been out of the legal press in England and Wales this year, and that's as a result of the ongoing litigation in Swift and Carpenter, which obviously followed the change to our discount rates. Originally in 2017, and then there was a further change in July 2019 to a negative discount rate. Now, prior to Swift and Carpenter, to work out how much a claimant could recover towards the cost of purchasing a new property, which they could then adapt to meet their injury-related needs, the formula used was from a case called Robertson Johnson. And this compensated the claimant for the loss of investment return on the capital, which would then subsequently be tied up in the property that they would purchase to meet their injury-related needs. Now, when the discount rate was 2.5%, which it was for many years before it was changed, the calculation worked. It was often provided insufficient compensation to meet the capital required, but it was a way of calculating these claims without overcompensating. When we switched to a negative discount rate, as I said, it no longer worked because the loss of investment on the capital investment in the property using a negative discount rate would be zero. So in Swift and Carpenter, the Court of Appeal decided that the previous approach should be departed from, as it no longer provided full, fair and reasonable compensation. And to avoid the risk of overcompensation, what the court said is you can't claim the full capital cost of the property that you now need, but instead you can receive the full capital cost less the value of the reversionary interest. And this is a concept which might seem a bit alien to our continental neighbours, to Solenn and Ana. It is a concept that comes from trusts law, I suppose, which values the life interest in a property. And so the court said that the reversionary interest in accommodation claims should be calculated on the basis of a market valuation of a deliberately cautious assumed investment return of 5% per annum across the claimant's lifetime. So for the claimant in Swift and Carpenter, she received just over £800,000 of the additional £900,000 capital she needed to meet her special accommodation requirements. So as Emma said, I'm in the firm's international injury team, and I take an interest in these matters because many of the claimants that I act for who suffered serious injury, they've suffered injury overseas, and a foreign law will apply. And this is where I turn to my experts in another jurisdiction to tell me what the law is and how we calculate the claim for special accommodation as a result of someone suffering a serious injury. And so I thought Swift and Carpenter was a timely opportunity to look at how things are approached in France and in Spain. So I'm delighted to be joined by Solenn and Ana. Solenn is the founding member of Le Tutour Advocates in Paris, and she's got extensive experience in aviation and catastrophic injury claims. And Ana is head of the personal injury department at her firm, Cremades and Calvo Sotelo. She's based in Malaga in Spain with decades of experience. You wouldn't believe it looking at her, but she's a very experienced practitioner in personal injury law in an international context. So two of my go-to experts who I'm going to turn to now to tell us a bit more about how claims for accommodation are assessed in their respective jurisdictions. So Solenn, kicking off with France as our closest neighbour, when a claimant suffers serious injury and French law applies, how do you approach the calculation for the claim for accommodation?
Well, thank you very much, Chris. Regarding the adapted accommodation, I need to say as a preliminary comment that it is actually listed as a loss in the Dantillac list of losses that needs to be indemnified by the insurer or the person who is liable. These expenses are listed in this Dantillac scale as the adaptation of pre-existing accommodation, the moving costs, the additional renting costs linked to the new disability, and the acquisition of a new home, taking into account the additional costs due to this acquisition, the expenses of medical structures as well, in addition to the victim's home. So these are the list of the list that is made on the Dantillac scale. Now, obviously, the French judge will look at the specific situation of each claimant, but there are some principles that are followed by the judge, depending on whether the victim remains to rent his own accommodation or becomes an owner of his accommodation, or if he was already owning his or her accommodation. If the victim remains in a situation of renting his accommodation, the calculation is made by the adaptation costs plus the additional cost above his current rent. That is the current rent per year, and which is multiplied by the life expectancy rate that is set by the Barremo de la Gazette du Palais, which is a scoring model decided by demographs and takes into account data, demographic data, and determines the interest rate. So the interest rate is already set in a way upstream the calculation made by the lawyer. So we don't really have to argue about that. The Barème de la Gazette du Palais is not mandatory, but it's really widely used by French judges. So the various numbers and prix de l'euro, euro price that is mentioned for each type of victims according to their age and the life expectancy is really widely used. So it's a very easy way of calculating what the additional cost of accommodation can be if the person remains renting. Well, I mean, still rents his flat or his accommodation. If the person acquires an accommodation, then if the person has to demonstrate that they had no other choice but to buy his own home, then the full price of this home is indemnified in addition to the costs of adapting this new home. If the victim can keep his or her home, her current home, then they chose to buy a home, then the indemnification will be the cost of the acquisition less the cost of the current rent that she would have paid anyway, on a life scale basis. And if this person was an owner and is still own and needs to buy something else, needs to buy an adapted home, then depending on the circumstances, they have to, the cost of the adaptation are indemnified, as well as the additional costs that needs to be borne in addition to the current home that they are living in. So it's relatively simple because the interest rate is already set in this barème de la Gazette du Palais, which is widely used.
And what's that rate at the moment, Solenn?
It's 0%.
Oh, okay.
Yeah,
so,
I just saw that. 0%.
The last time I was looking at it, it was 1.2%, but that was about 18 months ago, I think. So
okay, so but the Gazette du Palais is now, attends, let me say, l'influence de la croissance historique 2013, 0.6% in 2017 and 2019, and they say that it's now 0%.
Okay. Interesting. Well, I mean, one of the issues that the Court of Appeal was grappling with in the Swift and Carpenter decision was the claimant being overcompensated and there being a windfall to their estate when they pass away if the defendant insurer has paid the full capital cost of the property. But it sounds like that's not caused a problem in France.
No, they consider that. I haven't even seen a case law where a person who decides not to live in this new home and invests in this former home and rents it out, it's not an issue. This person can rent out the former home in where it was actually living and live this new adapted home, and there would not be overcompensation. But then obviously you will need to look at the situation, but then they consider that if a new home is needed with specific adaptation, then it can be indemnified. Yeah. But again, there is no proper rule there. It really needs to be looked on an individual basis.
A case-by-case assessment.
Yeah.
Ana, tell us about the position in Spain.
Well, first of all, thank you very much, Chris and Emma and Solenn. I'm very pleased to join you in this very interesting discussion. In Spain, we must first of all draw a line that makes the difference between victims of road traffic accidents and victims of other types of personal injury, of accidents which cause personal injury, because only those victims who have been injured as a result of a road traffic accident would have a specific regulation concerning how to assess their claims, which is the well-known Barremo, the Spanish Barremo, which sets scales for assessing injuries, and also it fixes the heads of damage that a victim of a road traffic accident can claim for. One of these being the accommodation cost, the cost of either acquiring a new property, adapted property, that suits the victim's purposes, in which case the price or the revenue obtained from the sale of the previous property, the one that was not adapted, shall be discounted from the compensation, or the cost of adopting the current property where the victim lives in. However, in both cases, the Barremo sets a limit, which is just over 150,000 euros. It doesn't give any much more detail than that. The only situation where we have been trying to broaden the scope of bringing a claim for accommodation costs is when the compensation refers to the victim's period of temporary incapacity, because in that case, until the point of stabilization of the injuries, the victim is entitled to receive full compensation. So that means that any costs, any expenses incurred by the victim up to the point of stabilization of the injuries, which are necessary for the victim to carry out his or her day-to-day activities and keep providing for his needs will need to be compensated in full. So that means that if the victim incurs during his period of temporary incapacity in costs which are intended to adapt his property to the needs that are caused by the injuries, this should be compensated in full. So this cap, the 150,000 euros cap, will only start once the victim's permanent symptoms have been assessed. So at that point, once the sequela have been established, we will have to assess the costs of acquiring an adapted property or adapting the current property, and this would be subject to the limit of 150,000 euros. Another interesting aspect that the Barremo includes in the articles which explain how the Barremo should be applied is that the Barremo expressly refers to the full compensation principle, and it also refers to the fact that in order to assess in order to establish the amounts of compensation under the Barremo and the caps under the Barremo, the personal circumstances of the victim should be taken into account. This means that when establishing the compensation under the Barremo, the figures are the result of assessing the situation of a victim living in Spain with the cost of living in Spain and the cost of properties in Spain. So there's scope to argue that when we are considering a victim residing outside Spain, these figures under the Barremo, the cap for the home adaptation cost, should also be adapted to the circumstances of a victim that resides in a country where maybe the cost of living are higher. So that's another point that gives some flexibility to this cap. And outside road traffic accidents, there is no compulsory regulation. There is no regulation at all, actually, which gives any kind of framework as to how these accommodation costs should be compensated. And most of the times, Spanish judges, they tend to refer to the Barremo as guidance, which means that even though this would provide some framework for the Spanish judge to know how to figure out how the claim should be compensated, there's no requirement, there's no legal obligation to apply these caps or to apply any of the caps under the Barremo. So that on the basis that the Spanish system recognizes the principle of full indemnity, should bring to the full compensation of the accommodation costs. However, we don't have any established way of calculating this, as Solenn was describing, as it happens in France. So it would be very much at the discretion of the judge as to how he thinks it's suitable to compensate the victim in such circumstances.
Excellent. Well, thank you for that, Ana. I mean, lots of complicated concepts that you've addressed there in, record time, I would say. But what I take from what you've both told us about the position in France and Spain is that there's plenty of scope for argument, and actually it's very much on a case-by-case basis, depending on the individual claimant. And in fact, I think we'll find, in fact, I've already found that the decision in Swift and Carpenter doesn't actually hold all of the answers for cases where English law applies as well. So thank you both very much for joining us today and providing the insights from France and Spain.
Thank you, Chris.
Thanks.